today we're going to talk about preparing for child custody and family court services. Now, I'll start with a little explanation for any of you that kind of aren't sure exactly what that means. So we're in California, and we're gonna give you things that are gonna apply across the board. So if you're not in California, stick with me. But I'm just gonna give you an explanation. We're in California, and in California, when there is a custody issue and the parents are in disagreement, we have sort of a social worker arm of the court that's called family court services. And these are usually child experts who either have an education or social work background that meet with the parties and try to help them reach agreement on what their parenting plan for the children are going to be. Now, in California, some counties are what we call recommending, and some counties are non-recommending. If you go to your court's website, you should be able to find that information. If you can't, you can always shoot me an email. We've got a spreadsheet actually of all the different counties and whether they're recommending or not. But if they aren't recommending them, it's basically like a mediation, and a lot of jurisdictions do call it family court services mediation. And what happens is, you go in and you try to work it out, and if you don't, then you don't, and you go into court and the judge makes a decision. Okay, that's right. A non-recommending county. If you're in a recommending county, like we are in San Diego, which is a recommending county, Riverside is a recommending county, Orange County is not a recommending county. LA County is not a recommending county. So we're in San Diego where it is. And so there what happens is you go in, you go in together, you try to reach agreement. If you don't, then that counselor writes a report to the court that the judge then uses as their guidepost for decision making on the child custody. Now, judges tend to rely heavily on that report because this person's considered a child expert in the case, and so that person's recommendation and opinion obviously weighs very heavily in the court.
I think that the best way to look at a child custody case is to understand the problems that are confronting your decision maker, whether it's the judge or whether it's a recommending counselor. The number one thing that they're trying to do is to protect the safety and welfare of the children. So that piece of it is kind of the gate that you have to go through. If you're an adequate parent, you probably can make it through that gate. Beyond that, the court wants to promote a peaceful resolution of your co-parenting issues, get you on a schedule.
Right.
They're going to want to identify any obstacles to you cooperating, like conflict. They are going to try to solve a set of problems. The problems being, what's the schedule going to be? How do we coordinate that schedule with the parties' work schedules? How do we make sure that the kids have an opportunity to have contact, frequent and continuing contact with each parent? And how do we, it's bad enough that the kids are going through their parents breaking up. How do we promote stability and continuity in other areas of their life?
What happens is you don't go to family court services unless one of the parties files a request for order on custody. And if one of the parties files a motion on custody, that's when you'll be sent to family court services. And the report generated often takes several weeks. So, you might have family court services 1 month, and then your hearing might be 2 months later, but you might not get the report till the week before. I mean, we've even had circumstances where the court called us and said you can pick it up the day of because they didn't get it done in time to send it out. So it depends on the counselors and the time frame and all that, but I just don't want you to be thinking it's unusual if you haven't received a report and your court date is getting closer, but that report is going to contain that tentative decision from the expert.
When you're addressing the court or addressing this person, you want to be respectful. You want to say Your Honor and that kind of thing, but not so that it makes you sick to your stomach.
Right.
because then it's obvious what's going on. So
Right.
Treat this person as an wise one, and remember that they're trying to promote a peaceful resolution. Identify your obstacles to cooperation, solve problems, identify solutions, and provide the court with a starting point to have a discussion about what the visitation and custody schedule should be. We talked last time about a curiosity stance. That's a good way to approach these folks is, we're struggling with this issue, and I'm wondering if you could help us with some solutions.
Right.
Do
you have any ideas?
That's a wonderful way to approach the recommending counselor.
Right.
Because it strokes their ego a little bit, let's face it.
Right.
But it also gives them permission to tell them what they think, tell you what they think, and it shows that you're being solution focused.
Right.
I want solutions. I'm not trying to screw over my ex. I'm not trying to take his kids away from him.
Right.
I'm trying to I'm here to solve problems.
Because that's really what they want. They want to know, how are we going to solve problems? And they want you to not be going after your pound of flesh or what makes you feel good or attacking the other parent. I mean, inevitably, if you go in and you're attacking the other parent, you don't get a good result.
True.
You know, but at the same time, I want to be clear, because sometimes this is what happens when we say that to people. People go in and pull their punches.
Right.
So if you have somebody who is an alcoholic, or you suspect is, or whatever, you have to address that. I mean, you can't let that go, but there are specific ways of addressing those concerns that aren't in an attacking way.
Right.
It's kind of like we talked about, I don't know, in the last episode or one before, where, you're trying to reframe the problem in more neutral terms. You might say something like, if your concern is the other parent drinking, you can say, well, I'm concerned because during the marriage, this person drank X number of drinks, and there are times that they have come to pick the children up and I thought I smelled alcohol, and I'm concerned because I don't know if they're addressing their problem or if there's some potential risk to the children. That's a lot different than saying, well, they've always been an alcoholic. They drank during the whole marriage, and that's all they're doing now. And they're never sober when they pick the kids up, and they blah 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 blah. Coming after them in that manner says it's about them.
Right.
But saying, I'm worried because I'm sending my kids with this person, and here's what I'm observing, and giving them the specific observations that you have, as opposed to telling them what the issue is. Oh, the issue is they're an alcoholic. Well, you don't have the expertise to diagnose them as an alcoholic, but you do have the credibility to be able to say they drank X number of drinks during the marriage, because I saw that with my own two eyes. They smelled like alcohol the last time they picked the children up, because I smell that with my own nose. So reporting your own observations.
You didn't smell that with your own eyes?
No, I hope not.
That's funny. That's what I thought you were going to say.
But reporting your observations is much more credible than reporting what you think the conclusions are. If you're showing the court that you're doing things to try to correct the problem, then that's when you're parenting, and that's usually when it's an issue, is when there's parenting, because it's preventing you from seeing your kids or having reduced time. And the parenting things will fall back into place, and we'll get back to a kind of a more normal equilibrium. But sometimes in those restraining orders, you start out with, we've had people that started out with as little as 2 hours of supervised time a week. And there is a way to increase that and get back to a normal, even 50-50 schedule if you take responsibility and you take the right steps.
Yeah, we've seen that happen over and over again.
Yeah.
What Tammy's saying before, don't pull your punches, it doesn't mean attacking the other party. It means expressing your concerns about what's going on in their world in a child-focused way.
Right.
I'm concerned that the kids are not being supervised properly. I drove by the other day and they were playing in the street.
Right.
So that's a legitimate concern.
Right.
Not he's an idiot, but this, I have this concern.
Right.
Is a
and
wonderful
even if he
word.
is an idiot, don't present it that way.
Yeah.
That's my recommendation. Because you have to understand that when you are in these reporting jurisdictions or in jurisdictions where this person's going to, write a report to the court, that's essentially what reporting jurisdiction means. A lot of times your case is won and lost right there. I mean, Thomas often said this is where the chili meets the cheese. That's his favorite phrase about family court services, because that report can be
I'm hungry.
difficult to. Yeah, is that
I like a chili. I want a chili dog now.
That's why you're using food analogies. But that's why these things can be so difficult, is because there's so much at stake. And you have to be careful how you're presenting this, because you're going to get, you might be able to get little tweaks out of the court from what that report says, but really, like you said, it's the anchor, it's the thing that's going to weight it all. And so we have people sometimes who will come in after they've had family court services, and let me just tell you that if you are preparing for this, you need to get educated. You need to get some, we do prep for it. Thomas does prep for clients and coaches them prior to it. There are many people in California that do that service, but
you don't want to go into this cold.
Yeah, you want to get some prep, because this is the anchor, and we've had people that have come out of it and who have gotten something like 10% custody, which don't ever use percentages. That's one of the things we teach.
We'll go into that.
Oh, we are? Okay, sorry, I'm getting ahead of myself. But they come out and they've got 10% custody, and then they make an appointment with Thomas and they say, I've got this FCS report, I've got 10% custody. I want to get 50-50. Can you help me? And it's like, well, no, probably I can't make that miraculous a change at that point. Oh my goodness, if I had a dime for every dad that says because it's fair. Don't ever tell the mediator that. They don't care what's fair. They don't care about you. They care about what's best for the kids.
Yeah.
This person's job is to be child focused, and what's quote unquote fair is not coming into the decision, because your children are not used as a mechanism by which to punish
or to equalize
or to anything else. It is, the only question is what's the best thing for them.
Yeah, really, it's a very child-focused procedure.
Right.
And, asking for what's fair, I want 50-50 because it's fair is just not a very strong argument in family court.
It's not going to get you anywhere.
Right.
I mean, I'm a little more direct. Thomas says, it's not a very strong argument. I'm telling you, it will not get you there. Don't use that.
It is an argument. I think that all things being equal, the judges want to make a fair decision, but it's not it's very, very low on the priority list of arguments, and so low as to not really be worth mentioning. The number one thing that they want to see is that the parents not have conflict in front of the children. I think that's number one. And then after that, there are the concerns that are in the statute, like frequent and continuing contact. I've gone to many seminars with the judges in the family law community in North San Diego County, and everybody that comes in and lectures us, and they're a social scientist of some kind, will tell us about studies that show that when children have access to both parents, they do better on just about every measure of developmental goodness or excellence. They just do better.
Yeah.
They adjust better to the parenting plan, and they do better in school, and they have less likelihood of delinquency, the whole thing.
Right. When you go into this, I mean, people tend to want to tell their whole story, and honestly, in San Diego where we are, most of the time people are slotted for about 20 minutes. Sometimes if it's really difficult, they'll run over, or you get lucky and the counselor didn't have anything scheduled after you and you get a little extra time. But honestly, you need to plan for about 20 minutes, because that could be all that you get. And so you want to be really focused. And Thomas always says, have a theme and have at most 3 key points that you want to make to the counselor. What most people tend to do is they get snarky, or they get nasty about it, and they're like, well, They're never around. They always work. They work 80 hours a week. They've never been present for anything. I've done all the parent-teacher conferences. I've done all the school events. I always do the homework. That comes across as a totally different presentation than what you just said. And
Right.
it conveys the same message,
Right.
except for that message is laced with, I hate the other parent.
Right. Yeah. If the other parent in your FCS meeting is being snarky and vindictive, you're winning.
Yes.
As long as you're not being snarky.
I was going to say, as long as you don't engage and fire back at them.
Right.
You know, one of the things that they usually tell you is keep your comments focused on the mediator or the recommending counselor, whatever it is. Same thing when you're in court in front of the judge. You don't speak to each other. You address all things through the judge. And so honestly, those kind of snarky, nasty comments, you know, like let's say your dad and mom is saying, oh, he's never been around, he's done this, he's done that. You know, if your dad, you might say, you know, Your Honor, or the counselor, ma'am, whatever, you know,
wise one.
yeah, that has historically been true, that the division of labor during our marriage was that mom handled the parenting and that I handled work. But, you know, since the divorce, I have realized how important it is that I be more involved with the children. And so I've spoken to my work and I've rearranged my schedule to where I'll be able to pick them up from school at least 2 days a week.
Right.
And that way I'll be able to have, you know, those 2 days plus my every other weekend and be able to really fully participate.
I got an apartment right across the street from their school and 2 miles from mom's house.
Yeah, and I'll be able to fully participate in all their school activities as well as, you know, their weekend extracurricular activities. And that's a way better argument than coming back with something like, well, the reason I'm never there is because she won't let me. She keeps me from seeing the kids, and she does this and she does that. And again, you're going to get a lot further if you can be kind of that voice of calm and reason. And if the other person's going off the deep end, well, that's all going in your favor then. So we mentioned don't, I'm just going to reiterate a little bit here. Don't ask about percentages. That just to the court, that says you're worried about money, because those percentages are used in calculations for support frequently. And don't talk about what's fair, because that's not child focus.
Don't talk about money.
Right. And that kind of goes along with the percentage thing, because if you go in and you start asking about child support, our counselors here will tell you they don't deal with that part of it. They only deal with the custody issue. And now you've probably put a bad taste in their mouth because you're asking about money straight off the bat.
But it makes you look like, because the child support formula is in part dictated by the child share.
Right.
So you don't want to convey the impression that you're just trying to maximize your timeshare so that you can get out of support.
Right.
That's not a good argument.
Right.
I can categorically say that's a bad argument.
Right.
You want to address these people as wise ones, as people who are experts and can really either help or hurt your case. And you want to make sure that you come in with an open mind and a problem-solving focus when you go in.
We'll grow in number, fueled by them to see the horizon, turn us to thousands.